Write a short note on compromise and arrangement under the Companies Act 2013. The terms compromise and arrangements are important concepts under company law. These provisions enable a company to settle disputes with its creditors or members and to recognize its affairs without resorting to lengthy litigation. The provisions relating to compromise and arrangement are contained in Section 230 of the Companies Act 2013. Compromise. Although the term compromise has not been specifically defined in the Companies Act 2013, it generally means an amicable settlement of disputes or differences between parties through mutual agreement. A compromise is based on the principle of give and take, where each party makes certain concessions to settle the dispute peacefully. A compromise presupposes the existence of a dispute or disagreement. Therefore, there can be no compromise unless some dispute exists between the company and its creditors or the company and its members, shareholders. Under Section 230 of the Companies Act 2013, a company may enter into a compromise with its creditors or members and settle disputes without resorting the court proceedings or arbitration. Arrangement. The term arrangement has a much wider meaning than compromise. According to Section 231 of the Companies Act 2013, arrangement includes the reorganization of the share capital of a company by consolidation of shares of different classes, division of shares into shares of different values, or both consolidation and division. Unlike compromise, an arrangement does not necessarily require the existence of a dispute. It may simply involve the restructuring of the company's capital, rights, liabilities, or business affairs for better management and efficiency. The meaning of compromise is settlement of a dispute by mutual agreement, while in arrangement we reorganize or reconstructing of company affairs. In compromise, existence of dispute is necessary, while in arrangement it is not necessary. The purpose of compromise is to settle differences between parties, but in arrangement the purpose is to reorganize capital, rights, or liabilities. The scope of compromise is to comparatively narrow, while in arrangement it is wider in scope. The parties involved in compromise are those of creditors and members having disputes between them, while in arrangement, creditors, members, and company structure, any one of them may be involved. Importance of compromise and arrangement. The provisions relating to compromise and arrangement help resolve disputes amicably, avoid lengthy and costly litigation, facilitate corporate restructuring, protect the interests of creditors and shareholders, improve the financial and managerial position of the company, promote smooth functioning of corporate entities. Conclusion. Thus, Section 230 of the Companies Act 2013 enables a company to enter into compromise and arrangement with its creditors and members, while a compromise involves the settlement of an existing dispute through mutual agreement. An arrangement has a wider scope and includes the reorganization of the company's share capital, rights, and liabilities, even in the absence of any dispute.